judgment, sir. For judgment, item 1.
It is partly allowed.
Item 2.
It's partly allowed.
Item 3.
Appeal is dismissed.
Item 4.
Criminal appeal allowed.
Item 5.
It's allowed.
Item 6.
Partly allowed.
Item 7.
It's partly allowed.
Item 8.
Appeal is dismissed.
Item 9.
Partly allowed.
Item 10.
Partly allowed.
Item 11.
Partly allowed.
Item 12.
Appeal appellate number 3 is allowed, and 1 and 2 stands partly allowed.
Item 13.
And appeal is allowed.
Item 14.
Partly allowed.
Item 15.
Partly allowed.
16.
Partly allowed.
17.
Partly. Yes. Yes, Mr. Challa.
Whole 3 million of hearing.
Or hearing. Hearing damage.
What happened?
Next week, Thursday, I think final hearing time.
This is not listed.
No, listed.
Of the fish mentioned.
List it. Are you ready to? Tuesday? Yes, Tuesday. List it. Tuesday. How it is escaped?
19.
19. Tuesday. Starts from?
Missing too much. Missing the mentions much on the
Oh,
iPad.
it's not live streamed or what? Live streaming is stopped.
Oh, yeah. That's it.
Who is there?
Item number.
Who wants to mention?
Not
Any? There are some Jacqueline, somebody is there. Anybody wants to mention? Online? Jacqueline, some Jacqueline, take it up.
just for the second. Text for the second.
Yes, madam.
Your Lordship, item 52 weekly. Seeking for a short adjournment, Your Lordship.
52.
52, Your Lordship. Criminal Appeal 554 of 2010.
Yes, you have been appointed, Maki.
Sir, amicus curiae, Your Lordship, seeking for a short adjournment, Your Lordship. Half of the file has been received, so I am not properly prepared today, Your Lordship.
Half of the file means what?
Some pages there is it's blank completely, sir. So I have to, Your Lordship.
Blank completely when you took out the printout.
I took out the printout.
Yeah, have you checked it? Here, it was
Yes, Your
those,
Lordship. I checked.
those
the
pages are there.
No pages are not there, Your Lordship. The LCR. I only received the LCR, not the paper copy, Your Lordship.
Huh? If you can take the file, you can
Yes,
take
Your
it.
Lordship.
Today you will you do it? Or
Your Lordship, short adjournment. I need to prepare it properly. And
Tuesday, come in the morning, see the file here and argue.
Yes.
Part of the file you have, the pages which you are missing, which you, according to you are missing, take it from here and argue.
Yes, Your Lordship. Yes, Your Lordship, any next date, Your Lordship. I have to make a note of
Tuesday.
submission also.
Tuesday, okay.
Yes, Your Lordship.
No adjournment will be given, huh? Tuesday.
Grateful, Your
Tuesday,
Lordship.
okay. Don't wait for papers. Papers are here. Come
Yes,
here,
Lordship.
sit there and read it and argue. Okay. Yes.
Item 1.
I see. No.
Item 1, there is 2 appellants.
Uh,
Out of 2, appellant number 2 in the meantime expired. I have already given the death certificate backside of the report, Your Lordship. Only respect of 1 is appeal will be continued.
Okay. No. To appeal abated in the absence of an application under 394 of CRPC, and the appeal is confined to appeal number 1.
Yes.
Yes.
40 the first one.
Yes.
Item 40.
40. Is there? Call from serial number.
Item 40 will take up first.
But he's not there. What? You are in item 40?
No, sir. Lordship, item 1 can be taken up after break.
Item 1 is over now. Yes. Item 2.
Item 2.
See, your old case, my lord, 99 affair.
90?
Affair. My lord has had this matter and specifically lordship directed the court below to conclude the trial within 3 months.
No, this is how
also conceived. Counter with the region.
is it now marked by the Honorable Chief Justice to this court?
Aslam Lord, your lordship has passed the last order in 402 application.
Okay.
Granting 3 months time. And my lord,
Now, what is the case is about?
Yes, I am coming to. Your lordship may see,
Yes.
so far as the FIR is concerned, there is an allegation against some
You are challenging a cognizance order of 2013. 2013 cognizance.
including the entire proceeding is not maintainable because I am coming to that, my lord. So far as PS 43 is concerned, they are saying that misappropriation of government fund. Lordship may see page 48.
48?
সেটা এ পর্যন্ত সেটা সেই পেমেন্টটা হয় নাই subsidy has not yet been disbursed.
So what are the facts? Let me understand what is the fact.
My lord,
Because see, there are cognizance order of 2013 you are challenging in 2025.
then my lord, 2024 charge has been framed.
2000? Yes.
And effect has been submitted 2000. Insufficient of evidence.
Yes.
In spite of lordship's direction, to your lordship may previous order, lordship may see that report was called for. Dita Saki, Setro, you would have Saki acting, Setro accused would Saki Asio go. As prosecution because like I am at the Gabuli, I am a party submission.
What is where is my order?
Lordship order, page. My lord, page 57.
57.
My lord.
Okay. Plus 57.
Your lordship has passed this order because Lord Court below wrote a letter, approach your lordship that some time may be granted so that I can conclude. That's why your lordship has.
Let us see.
সেটা হজুর
Passing of the order.
ওয়াশিং করে কইতে লর্ডশিপ may see that last page 60 there. Long pending of the trial proceeding, I pleaded experience to direct the special judge vigilance conduct to conclude the trial as expedient as possible within a period of 3 months. ତା ଭିତରେ 9 ମାସ ବି ଗଲାଣି। ଏ ଯୋଉ ଲାଷ୍ଟ ରିପୋର୍ଟ was called for ସେଠି ସେ କହିଲେ ଯେ
Therefore, you repeat another criminal miscellaneous, seeking the same relief.
My lord may remember, openly said that I will pass it. It will come in next.
What is the status, Mr. Mahanti?
Vigilance
Mr.
is
Maharana
the
Chapter.
state is not the vigilance. State vigilance is
Vigilance.
the is also my learning.
I'll issue notice to the vigilance. Let us see.
Lordship may see. Lordship may, they have filed counter. They have no objection. If Lordship
Counter in that petition.
No, this petition.
Let them come then.
Sit.
Notice
Lordship may
has
see the
been-
last order. My lord,
Yes, notice has already been issued.
22/9/25. Lordship may see that.
22?
22/9/25.
Yes.
Lordship may see.
Pointed out the Land Council for petition, fourth paragraph, line of so and so, here. Would have been mentioned, if yes, so and so. Review of the submission, so and so. There is the report.
Paragraph 5 times the
So
space.
and so.
Paragraph 5.
And perusal of it appears that
Peruse the-
trial was registered in 99 and the trial is.
That on perusal of
When
the
after
record, the appearance that
expiry of
the
the
vigilance
court of
FIR was
inquiry,
registered in
and
99.
two witnesses
The
have
trial
been
is still
examined
pending.
so far.
Even
The
after
report of the learned special judge vigilance.
expiry of a quarter of a century, my lord.
Persons have put
Only 2 witnesses have been
in
examined.
the meantime.
The total
In view of the aforesaid, how many accused are there? Total?
6-7 persons are.
Two of them had died.
These are my lord. My lord, informant already.
This court direct the standing of the witness or to file a affidavit. Where is the counsel? Where is the counsel? He has filed the counter affidavit, huh?
Already counted
After
is
that.
record. my lord. (24/7) and 24/10/2025 they filed the counter.
No. Lekho.
ମୁଁ ଡାକି ଦଉଛି sir.
If you can bring him, I can hear it.
Yes, sir.
Yes. Otherwise, I'll put it on Tuesday.
ଡାକି ଦଉଛି sir.
Tuesday, his name
He
is.
has no objection. Like in coordinate bench, he has stated before the honorable court saying that
but his
already
name
we
is
have filed.
reflecting. Whose name is there?
N. Maharana, Niranjan Maharana. नाटा नहीं.
Then I have to write. Marana was appearing.
I call.
Call him.
Okay.
Yes.
Pass.
Yes.
Item 3.
Lordship, item number 3, can you take it after lunch, your lordship? Mr. Pal is to argue this matter, your lordship.
What is this matter, by the way?
Lordship, I am challenging the FIR question, your lordship, and filed this LMC for FIR, your lordship. I am challenging the FIR, your lordship.
Challenging what?
Your lordship has, lordship kindly see annexure 6, your lordship. The lordship has, since the investigation of the present case is at the national stage, I am not inclined to entertain the present petition. However, liberty is granted to the petitioner to apprise the investigation officer, the entire case. It is expected that the investigating agency shall deal with the contention of the petitioner in accordance with law. It is the earlier, I have filed this application, lordship, and it was and this order has been passed, but till date it has no action has been.
Have you read the brief?
No, no, your lordship, I am not prepared yet. That's why I seek some.
Urgent. On the request. Yes. Next.
Lordship, can you take it after lunch?
No. I'll read. I will concentrate on appeal. Yes.
Lordship, kindly pass over, your lordship.
I'll take it up next.
Item 4.
Tuesday or Thursday. Yes. 4.
And then
4.
Anybody is ready in any of the matters?
Extension of time.
Okay.
Item 5.
Extension of time.
Extension of time.
You will-
Based on measurement time.
Okay. For the reasons stated in the application, the time to surrender before the court by the petitioner is extended up till 1st of January You have paid the cost?
Yes, I.
First January, it is made clear that no further exchange shall be granted in any circumstances. Yes.
Item 6.
May I please, Your Lordship?
Yes.
Lordship, prayer for extension of time, my lord.
For the reasons stated in the application, the same is allowed. And the time for surrendering by the petitioner before the court below is extended up till 1st of January. It's made clear that no further extensions shall be granted in any circumstances. Yes.
Item 7.
Item 7, my lords, your lordship by order date 17/4/2025 had directed for an expeditious trial. There's a letter at flag A by the learned additional district judge come special court for some more time to
Yeah.
complete the
That's
trial.
also the order dated 17
4/2025.
2025. By the order dated 17/5/2025, how much time was granted?
6 months, my lords.
6-month time was granted to the learned trial court for conclusion of the trial. After the expiry of 6 months, the additional judges come special court under POCSO Act has submitted a report dated 13/11/2025. That is how the matter is now today listed. As per the learned trial court is seeking extension of time for another 3 months to conclude the trial for the reasons stated in the letter written by letter dated 13/11/2025 written by the learned trial court. I'm inclined to extend the time for another 3 months. For concluding the trial as has been directed by order dated 17/4/2025. Yes.
Wait,
Yes.
Item 8.
What is this matter? Huh?
Not my matter. Ask to take a pass on the motion.
Let us see if it's deserve passover or
Amendment.
huh?
Amendment consultation.
Amendment of
Consultation.
yes.
File an IE application for amendment.
Amendment of what?
Prayer, Your Lordship.
Huh?
Prayer, Your Lordship.
What was the prayer earlier?
The prayer was to watch the entire proceeding,
Yes.
but after the
Breathe.
filing of the charge
Breathe,
sheet,
breathe, breathe. Yes.
next item is.
Do you have an objection?
But sir, I have no objection if the prayer person will be set for amendment by my friend.
Shall I record in? You don't have a
Yes, sir, but in fact, the petitioner earlier challenged in questioning the entire criminal proceeding, but now come with an amendment to amend the prayer. Also.
I mean prayer what now?
Prayer
praying
to,
for the inclusion of the charge sheet, Your Lordship, which has been filed in the year January 2024.
You want to challenge
Incorporate
charge
in-
sheet now?
incorporate.
Filing of charge sheet.
Your Lordship.
That you can file anyway charge sheet. At the stage of framing of charge, you can very well argue all these points. Anyway, for the reasons stated in the application, the same is allowed, particularly because the State Council has no objection to such amendment. Accordingly, the petitioner is directed to file a amended and probably consolidated petition within a week.
Lordship, I'll be fine. Okay.
Within a week, lease the matter for hearing. Yes.
So, Lordship, next week, Your Lordship, for
Next week. Okay. Next week.
Hearing.
What is this matter? Is good?
this matter is pertaining to Your Lordship where an FIR has been lodged. I have introduced certain accused persons to the informant. The informant basing on the statement of mine, Your Lordship, I have introduced the accused persons. Now the accused persons have taken away 69 lakhs from the informant. I have not received anything from them. I have also indirectly, I have also suffered in this case. What has happened is I have also paid the admission fees of my sister to the accused persons, which has not been returned back. which has not been returned back to me, Your Lordship. So
You say that you are also a victim,
yes, Your Lordship, I am a victim in this.
but you are made as an accused.
Your Lordship.
Okay, we'll see. See. Okay. Next week. Yes.
Hearing. Item number.
Yes. 9. Nobody there. Huh? Let's see. On the next Tuesday, I'll appoint Mikesh to repeat it because it's H.S. Mishra's case. Then he'll come and.
94 by 3 times.
Hmm?
4 by 3 times.
Ask him. Otherwise, we'll appoint after lunch. We'll appoint.
Item 10.
In here is two appellants arrived for 5 years for 304 part 2 Your Lordship and 149, and arrived for 3 months 323 and 149 Your Lordship. In the meantime, appellant wants an expired Your Lordship.
Yes. Who is appearing in this matter? Hmm?
Captain Mr. Lenka's name is there. Mr. N. Lenka's name is there.
Item 10.
9 and 10, I will inform Mr. Mishra and Lenka.
You inform otherwise these are from 94 there are only 3 matters. If he's not interested then somebody of you can only 3 matters from 1994. At least 94 issue will be over once the 3 matters are over. You people can take the responsibility.
His daughter is not informed.
Mr. Lenka in the item 11 Ashish Kumar Mishra. Order कर दो. Despite repeated call, these matters are listed in the weekly list. Every on each date of hearing, the matters are called, but none appeared. None appeared. Today, when finally the matter were called for hearing, even none appeared. None appeared. None appeared. In the interest of justice, the matter is adjourned to Tuesday. It is made clear that no further adjournment shall be granted in this matter. In this matter, 9, 10, 11. If none appears on the next date of hearing, a Mikesh Kuri will be appointed for the purpose of assisting the court. All the I have indicated that if nobody comes, then I'll appoint Mikesh Kuri Tuesday. Okay. All the 9, 10, 11, 12, 95. Here also nobody appears, it seems. None. More matter I'll take up that, but these 95 matters, his appearance is there. One Mr. Deepak Mishra. Mindlessly, people write the name, even if they are not present. If none appears for appellant, you must write none appears. So simply write the names. Whether it is the Honorable retired Chief Justice Deepak Mishra or another Deepak. With the 95 matter, maybe Justice Deepak Mishra. Who knows?
If this
His appearance is recorded.
if this matter will be alerted to us, now will be obliged.
But if somebody else will come, then that's the problem. Once what is happening is, if I appoint Mikesh Kuri and Mikesh Kuri prepares the matter, when he appears in the court, the original lawyer comes. This is very embarrassing, you know. You disappear for many hearing when the amicus curiae comes prepared, then you drop.
Twice.
This is very embarrassing for no.
We contact, yes.
That's the whole difficulty. I लिखी दियो 95 रे 95 जति मैटर अछि ना same order. Let us have a proceeding and Tuesday appoint amicus curiae. Otherwise this will never happen. 95 and what about 13? Tako. 13.
Item 13.
This item will be taken up on Thursday. I'm not prepared yet.
Okay. Okay. 13 अछि, yeah? 14.
14.
It'll remain in the list. Get ready, yeah? 14.
2 years 1,000.
Huh?
2 years 1,000.
Same here. 14B. Same order कर दिया. Same order कर. 14.
15.
15.
Shopping plans abated against the appellant.
What is the offense?
324 1 times the offense. If the lordship may be kind enough to fix a longer date for this matter.
No longer date. 95 matter, no longer date. It will remain in the list. Either do it next week or I'll pass the order. No longer date. You want that all the accused should naturally die, therefore you are waiting or what? Then it'll come everything. If you remain like this for another 10 years, then all the accused will die. Let it remain, huh? Okay, next.
Item 16.
16.
15%.
It will remain in the board. Remain in the board, yes. 16, 96 matter now. 96, there are two matters only.
96 there are 2 matter.
96 देखो. Target till 96.
होती
ये क्या आचार्य?
96 item 16 है ना.
चलो ठीक है, इतना रखो 96 तक. ठीक है? नहीं 96 तक रखो. ठीक है? ये भी खोल दो. ठीक है? 96 में ऑटो करने मिस्टर. ये क्या आचार्य अपीयरिंग है?
हाँ, एक है
Yes, go. 17, are you ready?
16.
16, ready? 96.
I'm ready. But,
Oh, proceed then.
Well, that answer will not be available because it's a case of 304 part 1 pertaining to criminal appeal number 24 of 96. But 304 part 1 also relates to death of a person. Culpable homicide not amounting to murder, but what has happened in this case, all the accused persons were charge sheeted for the offense under section 304. But charge has been framed with regards to the appellant Sukkal Malik for the offense under 304 part 1. And accordingly, he has been convicted the said offense and been sentenced to undergo RI for 5 years. Pertaining to others matter, criminal appeal number 10 of 96, they are matter
Because there are 2 appeals, it seems. Huh?
2 appeals.
One appeal is filed by
One conviction, one judgment.
Tukal.
There are 2 appeals.
Huh?
One judgment of conviction arising out of that.
Yes.
2 appeals.
Tukal has filed a separate appeal.
Well, has filed a separate appeal. Here, matter the other accused persons in criminal appeal number 10 of 96, they have been convicted for the offense under section 336. Major offense is 336, as has been sentenced to undergo RI for 6 months.
In criminal appeal number 10.
10.
Only 6 months.
6 months, matters.
Yes.
And with regards to 323, 448, they have been acquitted and convicted for offense under section 147.
304 part 1 is also there.
304 part 1 is with regard for
5 years. I sentence the convict Sukal Malik.
Sukal Malik. Well, with regards to Sukal Malik, the trial court has taken note of the evidence of PW 6, 7, and 8
Yes.
to reach at a conclusion that Sukal is the person who was given the fatal blow, basing upon which
What is the undergone period insofar as these people are concerned? In 10, they might have undergone substantive period because 302 was the initial FIR, it seems.
FIR is 302, charge sheet has been submitted under 304.
So therefore, they might have been taken into custody in the beginning. Just check it up, their period undergone, because 6 months is the sentence. Then in appeal number 10, only 6 month sentence, 336. Isn't it?
Here also, my lord, with regards to Sukal,
Let us see Sukal, what is what?
my lord, evidence of PW 6, my lord, we kindly see.
BW6.
My lord.
Yes.
My lord.
Yes.
6 is claiming to be witness to the occurrence. He says, my lord,
House of Bhagwan Patil at 2 p.m.
my lord,
and pelted stone to the house of
paragraph 1.
I myself and my father and the brother. So
The
this
servant of
what
Bhagwan approached
Bhagwan Patil came
and
out
protested
of his
about the
house
assault
and the accused Upendra
at this.
said to catch him, and Bhagwan was inside the house. Again Upendra accused said that Adu rushed into the passage room and brought out Bhagwan. The wife of Bhagwan also came outside, seeing the dragging husband. Again Upendra also this Povitro delte Tangiablo. Povitro delte Tangiablo.
That is with regards to Bhagwan. Bhagwan Bhagwan Patel, he has not been examined. Informant has not been examined. And Pavitra's assault is pertaining to Bhagwan. But with regards to the deceased,
Who is the deceased?
my lord, deceased is
Then,
Neti,
another property.
Sukal Neti. So Dr. Neti. And my lord, we see evidence of PW 6 towards the last 4, paragraph 1, last 6 lines.
At this, Sapala came.
Suphoda came.
Sapala came.
Suphoda is an accused.
Hmm.
And allegation of PW 6 is against Suphoda at the first instance. Well, that evidence continues. And
Close to the head of
after that, he was recalled. And he has made Suphoda as Sukal.
those days, type machines can write anything.
That is the observation of the London Trial Court in paragraph.
Maybe that may obviously I have not read it, but that
Paragraph 9 of the judgment, Trial Court has been pleased to observe course, PW6 has committed a mistake by saying the name of Sukkar, appellant, which may be a mistake due to his pronouncement.
I'll tell you the very interesting thing in Delhi High Court, on those days, cause list used to be typed in typewriter. One Bhupender Singh, a senior counsel, fairly senior, not designated senior. His name was Bhupender Singh. It was written Bandar Singh. And he came and gave a complaint saying that, see, my name is written Bandar Singh. Bhupender Singh. High machines are like that. What to do?
Then he said pronouncement was wrong, for which
Sufala and this accused name is
Sufala
quite-
Sufala is an accused also along with others.
Sufala.
Sufala is also an accused.
Accused number 2.
Pilot.
Yes.
So he said Sufala at the first instance, but subsequently he was recalled by prosecution, and he has stated in paragraph 8.
In recall.
Resumed an oath being recalled after some days. I know all the accused persons, I know their names, the witnesses identified Sufala Patel. The doc had said his name, I do not know his father's name. There is also another accused in the doc whose name is Sufala Malik. I do not know the father's name. The witness identified Sufala Malik who dealt a Medablo to the head of the Nakro city.
Shukala Malik and dealt Matablo to the head of the Nakro. And it's very clearly clarified.
Huh.
Sufala Patel had not dealt with the Matablo. And it is Shukala.
And
Shukola.
the doctor says,
Shukola and Sufala.
Sufala,
And Sufala.
Sufala,
Sukla is the real accused. He has taken the name of Sufala. And he clarified that it's not Sufala, it is Sukola. Okay.
Here, one thing that comes to my mind, madam, the doctor says
He is the only eyewitness.
7 also valid. 7 also.
7 also.
7
Let us
also
see.
says valid initially Sufala. And to Sufala dealt a Madhavro, valid may see for chief.
Nay, what the PW7 says?
Sufala.
Sufala.
Let me see around 1340 line first paragraph. I know accused person should start meeting. Thereafter, Dhakulo came out of the house of Bhagavan and asked to why his master was
Upendra said,
assaulted.
"Dekho."
Then Upendra said, Dekho, selecting
He said, Sukola dealt a blow.
blow to the head of Dhakulo.
He says Sukola.
Malad.
Then there is no problem here. In PW7 is concerned.
That is not.
PW6 clarified it. PW7 says Sukola, not Sufala. Okay.
But he has also stated in the cross they have brought out. At that time, Sukola also, at the same instance from Nakula, Sukola immediately assaulted Nakula at the spot from the same distance. But a day, what I want to draw minors' kind attention that the doctor has, doctor is PW5,
PW5.
1.
sorry, 1. PW1, but let me see.
Yes.
Also found one stitch tool 4 inches in length over the scalp above left eyebrow. The underlying skull bone was fractured, so and so. There was lacerated of brain 3 inch with broken bone.
Skull bone
But
was fractured.
2 injuries he has sustained. But and he says this is a sustained 2 distinct injuries. If 2 distinct injuries have been sustained by the deceased, and the one injury is attributed to the present appellant, so who is the author of the other injury that is not there? Let me kindly see. Paragraph 2. I cannot say the time limit for reduction of swelling substance of brain bacteria after treatment. I cannot give any opinion if applying steroid injection or
Steroid injection or
steroid injection or
manital injection.
medical injection. The brain substance swelling will reduce within 3 to 5 days. In this case, there was one external injury. If a patient
In this case, he says that in this case,
There is one external
Only
injury.
external
If a
injury.
patient with such injury is
Patient
removed to a distant
such
place,
injuries.
say about 150 kilometers without treatment, then during transit there will be deterioration to the condition of the injury. The quantity of jerk and jolt during transit may deteriorate the condition of the patient further. I cannot give any definite opinion about the duration of such and such injury. Patient is no treatment is given with suppressed. The chances are better if such a patient. Chances are
He is
better if such a
treated
patient treated
in the-
neurosurgery department. Neurosurgery doctor is PW5.
Yes. What PW5 says. So in this, the evidence of PW1, you want to highlight that portion
And
that he had received two injuries.
uh,
The other injury, the author of the other injury is not explained
by
by the prosecution. This is your. At PW5, what does he say?
prosecution the brother of the
There's
patient.
the assault to the head of Nokuloneti.
Eh?
The 4 line from the top, Your Worship.
A skull bone fracture. That's there.
It's the assault to the head of Nokuloneti.
Where are you reading? Where are you reading?
PW5.
Huh?
The 4 line from the top.
Yes.
There was assault to the head of Nokuloneti according to
Head of the Nokulo?
he was
Neti.
unconscious from the time of injury till he was taken away by his relations after operation, that is 10/5/1994. The bedhead ticket does not disclose that Nokuloneti recovered so and so. On 7/5/94, there was an operation on the head and it was found that left front parietal bone was fractured and its size of 3 × 2 cm. That bone piece was depressed and damaged the brain.
Piece of the
substance underlying.
depressed and damaged
The
brain
underlying
substances in
covering of the
underlining.
brain, that is dura
The underlying covering of the brain.
depression and brain was coming out. The dura was closed and wound was closed. He remained unconscious with the right side paralysis and loss of speech. The relatives had given a bond and had taken away the patient so and so.
Would have been given by that, he would have
He
survived.
was given the proper treatment, Your Worship. Your Worship,
Let me see paragraph 2.
surgeon.
Paragraph 2. Neurosurgery has given you the endorsement that the relations of the patients are taken away from the hospital as against the medical advice. The witness had gone through the endorsement in the Xerox copy of an answer. On 2nd and 3rd May 94, no operation could be conducted because of breakdown of the operation table of neurosurgery. On 4th and 5th, the relations of the patients were not available, for which operation was postponed. On 7th, operation was done because prosecution Lethi was available and thereafter in the execution of a bond, the operation was done. The witness answer after going through the one text besides operation, there were supporting treatments within 2nd May to 7th May, and thereafter operation was a curative measure in this case. The bone pieces of the fractured bone were removed at the time of repairing of the brain materials.
No proper treatment could not be given because non-cooperation of relatives.
Cooperation of the family member.
Given of the proper treatment is not a defense according to section 300. That will be my submission.
IPC 300.
And he was taken to the hospital.
300. Yes. Which exception?
Minus.
Section 299, explanation number 2.
Huh?
Section 299, explanation 2.
299. Yes. Explanation?
2 years.
2. Okay.
I'll just read the 299.
Where the death is caused by bodily injury,
The person who
the
caused
person who
body-
caused such bodily injury
who have caused the
shall be
death,
deemed to
the-
have been caused the death.
proper remedies and
Although by
skillful
resorting
the
to a
death
proper
might have
remedy,
been prevented.
the skillful treatment of the death might have been prevented. So explanation 2 to section 299.
299.
Exploitation 2.
And moreover, your lordship,
If
the
he
rel-
dies, then it is homicidal death, irrespective of the treatment not given properly.
and
Because the injury was such.
yes, sir. And one more submission, your lordship. In this case, he was taken to the hospital. There are some on the second and third as it appears that there was a damage in the hospital for which the operation could
No,
not
but
be
the doctor
completed.
says that because the attendants were not there. That is, attendants may not be there if
Yes, sir.
his life is in imminent danger. The doctor should have done it, not waiting for the attendant to come. That
And looking at the injury, he has sustained a fracture and that has gone into his brain and his brain matter has come out. Seems to be.
skull is fractured. Yes.
Yes, but
Yes.
why don't we see also the evidence of PW9?
PW9, huh?
The doctor, yes, another doctor.
Another doctor. PW9, huh?
The DHS where he was first referred.
Huh?
And
He is the person who has treated the injured persons and also doculosity at the first instance. Why don't we see PW9 paragraph 3? On the same day, I also examined doculosity, son of so and so.
Paragraph?
3.
Yes.
On the same day, I also examined
No clue.
doculosity, son of Kadas of so and so under other PS, police requisition and found the
Following injuries. Lacerated wound.
lacerated wound of size 2 inch into 1 by 4.
There are 2 injuries.
Madam. 2 injuries.
and all over the skull here.
Yes, yes. 2 injuries.
What he says that single blow, 2 injury. Not
Yes.
explained.
Madam. And doctor says the injuries might have been caused within 6 hours and none of the cross-examination, none of the injuries found on the person of Bhagwan so and so. The injuries are the person of toxicity are distinct and distinctly placed. So these 2 injuries can be caused by
Two different
persons
injuries.
or by 2 blows. My specific case of prosecution, I'm not disputing Nakulo or Nakulo. I'm disputing PW 6, 7, and 8. If that will be taken on their face value. The one injury is attributed to Nakur is present appellant.
Mm.
Who is the author of the other injuries? Very fast submission matter. If the person concerned has died out of these 2 injuries, and I am the author of one injury, who is the author of the other injuries? And for that,
But it doesn't, none of the doctor says that because
Who
of
is
both the
it?
injury he has died.
both the injuries.
Which injury he died, nobody says anything.
How I will be held responsible for 304 part 1? The others will be acquitted from the charge of the 304 part 1 and 333, 36.
Lordship, I'll just place PW 6 and 7 again. Can I?
Yes. 6.
And
And 7.
to start with.
As a start from the very beginning. The accused persons are my co-villagers. I know
Where are you reading?
PW 6.
You are reading full?
PW 6, your lordship.
Yes. Read little louder.
Yes, sir. The
This
accused
occurrence
persons-
took place in the month of Vaishak and so and so. The accused persons came to the house of Bhagwan Patel at 2 p.m. and pelted stone Bhagwan and I myself, father so and so.
I myself, my father's elder brother, saw this at the
Our in the informant, but he has been withheld from the prosecution pay.
Bhagwan Patel.
Bhagwan is the informant,
Informant.
but he was not examined.
But he has also injured.
Hmm.
Allegation that he has been assaulted by sharp cutting weapon, but injuries are lacerations.
Hmm.
I don't know why prosecution will
Not
kept him,
examined.
but not examined them.
Bhagwan not examined.
No matter. He is the leader of the group. Admittedly, that is the prosecution case. One leader of one group is Bhagavan Patel, and then the other one.
He should have been a naturally natural witness for you. For some reason must be there to
He has
withhold
been
him.
prosecuted.
His non-examination doesn't affect. the
No,
process.
not examination doesn't. But see, if it is suspicious, he is the person who received injury, and he is the person on whose house everything has been done,
Yes, everything has.
and he is the informant.
And he is the person
Other
for.
witnesses. I'll just read
He is the person.
6 for him.
He is the person, my lord, under whom other persons, my lord.
So is doubt is being created. Why you have not done? Yeah, anyway, let us see.
I myself and
Myself
my
and-
father's elder brother saw this at the spot. Bhagwan Patel came out of his house and the accused Upendra said to catch him. The Bhagwan rushed inside his house. Again, Upendra accused said, "Corner the Khojo." At this, Pavitra and Hadu rushed to into the passage room and brought out Bhagwan. The wife of Bhagwan also came outside, seeing the driving of.
Wife of Bhagwan is examined.
I'll just have to check it.
Check it up, huh?
I'll just check.
Yes.
it.
Seeing the dragging of her husband,
Yes, sir.
and again,
Again, Upendra Prasad.
Upendra said, "Kon korcho," and
At this,
Pavitra dealt a tangia blow.
the head of Bhagwan and then another blow to the right leg. He sustained.
Two
bleeding
blows
injury.
given to Bhagwan, huh?
Yes, sir.
Yes.
He sustained bleeding injury. The field servant of Bhagwan Nakulaneti came out and protested about assault to his master. At this, Suphala came and dealt a mera blow to the head of Nakula. As a result, Nakulaneti fell down suddenly on the ground. Nakula sustained bleeding injury on his head. Accused person ran away after this incident. Came to the spot. Dhova Sethi came to the spot, to whom Bhagwan Patil requested to arrange a vehicle to their shifting to hospital. Dhova Seth went towards Bandhar to go towards Balangi for arrangement. Since he did not return for some time, we shifted Bhagwan and Nakula to the house of Bhagwan. I can identify the weapon which is Suphala assaulted Nakula, MO1, is that Mera. The accused person were being armed with Mera and axes when they were pelting stones. Sankara Malik is also known as Hadu. Raju Malik is also known as Bundiki. I know Hare Krishna Patel. It is not the fact that my land adjoins to the land of
The
Hare
second
Krishna.
injury, have you explained by at least suggesting that
Yes,
this is caused
yes,
after
I'm
falling? Yes.
Nor we exchange bullock for our cultivation. It is not a fact that the witness Uday Patel and my elder sister are sworn friends. It is not a fact that I myself, Doba Parwa, are sworn friends. It is not a fact that I address Bhagwan as my brother-in-law. There are two parties in the bill. It is not a fact that I Rakesh so. Thereafter, Rakesh Rakesh is my father's elder brother. It is a fact that Rakesh instituted a proceeding of 107 CRPC. It is a fact that Bhagwan Patil was a witness in that proceeding. Dulava belongs to counter group. I do not know about the counter case instituted by Lakshman Mali, who belongs to the other. It is not a fact that Upendra Patil so-and-so. Paragraph 8. I know all the accused persons. I know their name. The witness
Paragraph?
8.
Hmm.
I know all the accused persons. He was recalled for that examination. He was recalled.
On recall, yes.
Recalled. I know their name. The witness identified Suphala Patil in the dock and said his name correctly. I do not know his father's name. There is also another accused in the dock whose name is Sukhala Malli. I don't know his
He
mother's
clarified
name.
in para
He
8, it is
clarified,
not
yes.
Sufala, it is
It is
Sukala.
Sukhala.
Yes.
The witness
That's
identified
there.
Sukhala Malik who dealt a mera blow to the head of Nakula Sethi. Nakula Neti, Suphala Patil has not dealt mera blow to the head of Nakula.
It's clarified. Okay.
I had seen Nakula at 2 p.m. once. Then rest of the portion may not be. He says accused Sukhala is a right hand.
I had seen it. No, you read para 9.
I had seen.
But I
Nakula
had
at 2 p.m.
full para 9.
Yes.
I had seen Nakulo at 2 p.m.
Date of
occurrence.
He was in the side of house of Bhagwan Patil. I had not seen why Bhagwan Patil. I had not seen Nakula on the village road, but I had seen him 2 p.m. in the house of the Bhagwan. When Bhagwan was assaulted, Nakula was inside his house. Nakula did not intervene when.
Nakulo did not intervene.
I'll come.
When Bhagwan Patil was assaulted.
Nakula did not.
Nakulo at the
when
distance of
assaulted.
2 cubic feet from Bhagwan.
3 cubits from the Bhagwan. The former was assaulted.
The
Nakula was at a distance of 4 cubits away from Sukhala. Sukhala assaulted from backside from that distance. Accused Sukhala is a right-handed. He dealt a mera blow using his both hands. Sukhala is taller than this is Nakula. Nakula was standing when he received the mera blow. Nakula received the mera blow in the middle of his head, slide towards the left side. The witness points to the position. That was the only mera blow given by the Sukhala to the deceased.
This is very important. Just see, very specific. That was the only mera blow given by Sukhala to the deceased Nakula. And again confirm that single blow, reaffirm. I had seen that the incident from the front of the house, and after seeing the result, myself and my father went to spot, and none of these with so and so. Not that he fell down, so that he got the injury.
That suggestion may not be that. I'll come to PW
So after
7.
going through my this cross-examination, I council number again, Asud Khan.
See that question very specific.
Very close.
Huh?
And
Very
that
interesting question.
police-
The question should have been
See, this is the cross
This
examination,
is
real
the
cross.
the question should have been put to the medical officers who examined whether both the injuries can be possible by one blow. That could have been the question for the
So
medical.
are you-
But nothing of that sort has coming forth. And rather, in the contrary, it says that the
Yes.
only blow given.
Only, had it been a question to the medical officer whether that bio of Mera
Yeah,
have
possible. There are
would have been possible.
two distinct, and the doctor is so meticulously examined, saying that that blow is distinct. Both the blows are distinct.
They say injuries are distinct.
Separate injuries are distinct. That's what there are two blows. It is very clarified now, very much clarified that there are two blows.
They have not clarified.
And eyewitnesses says that single blow.
Single. I'll just place PW7. I'll just continue.
Okay, PW 7. Okay, good.
Yes, sir. PW7.
So 6 is
Six.
you can't get anything out of 6. Let us see 7.
So delta blue, out of which he died.
That part is there.
I know the accused person. There were my four villages. This occurrence took place on a Sunday of the month of Vaisakha of last year at about 2 p.m. I was in my house when I heard a shout. I came to my outer veranda. Amar followed me. He is the son of my younger brother. I found that the accused person was shouting in front of the house of Bhagwan Patel. They were armed with lathis and miras. Gunnu Mahaling was holding an axe. The accused persons were pelting stone to the house of Bhagwan, for which he came out and asked the reason. At this, Upendra Patel said, and Gunnu Mahaling dealt a farsa blow to the right side of the Bhagwan and another blow to the right side. Bhagwan fell down. Thereafter, Nakula came out of the house of the Bhagwan and said as to why his master was assaulted. The
The accused Sukolo dealt A, huh? A blow to the head of the Nakula.
Here when Sufar, and this Sufar has not been clarified. Here when the accused Sufar, then they made a blow, not Sukar.
It is Sukola or Sufolo.
But the certified copy says Sufar.
But the TCR said that has been corrected.
But the 7 has 7. No, 7. 6 has done
Let me
it.
see the
Not 7.
certified copy, which will be denied.
Okay, let us see further.
कट्टा है कि साइड रे साइन नीचे जज कर
देखियो
देखिए এটা স্যার
ଇ ସୁଫଳ କହିଛି ଏଠି ସାଇନ୍ କଣ ହେଇଛି କେ କରିଛନ୍ତି ଏଠି
हां
କେ କରି ସାଇନ୍ ହେଇଛି
ଶ୍ରୀରାମ କେ କରିଛନ୍ତି
କେ କରିକି ଏଠି ସାଇନ୍ ହେଇଛି
शैल नीचे
ଏଠି ସୁକଳ F and K, that's the only difference. दे दो सुकଳ anyway because 6 is that much will not make difference. Okay.
it of Nakula. At this Nakula fell down. Thereafter the accused person ran up. Where when Dhobaset came from outside from the side of the house, Bhagwan requested him to.
But here he says at this Nakula fell down. Okay. But let us see somewhere if you can get something that injury might have been caused because of the fact that he fell down. Because see, the injury was from back side. He fell from the front side. So another injury may be possible also, second injury. Whether any evidence is coming forth. Just check it out. Any suggestion anywhere, anything.
also been clarified by P27. He has received one injury by on the backside of the leg.
Same.
Lordship was asking whether the Bhagwan Patel's wife has been examined. She has PW 8. PW in paragraph 2, she says Sukkala blow to the head of the knuckle. As a result, she failed. When he fell down, he lost his sense.
Okay. Move down. Move down, move down. So nothing of the sort, no suggestion
No
that he
suggestion.
fell down as a result of which he might have got another injury. That is not there. 7 also doesn't say that. So there are two things are very clearly coming out from the evidence. First is doctor found 2 blows, witnesses say 1 blow. This is one.
Injury.
2 injuries.
2 injuries.
Cause of death is attributable to both the injuries. It is not clarified, so both the injury might have been the reason for the death. This is what is coming out from the evidence of PW1 and 5 as well as PW9 to some extent. And the Bhagavan and his wife, who is in whose house everything has happened, and they are the natural witness and eyewitnesses, they have not been examined. None of them.
Examined. His wife has been examined.
Examined. Wife? PW?
8.
8. Let us see PW 8 was.
She also
Bhagavan is not examined, but wife is examined.
PW 8. In paragraph 1, she says exactly what 6 and 7 say. Paragraph 2 would be relevant relating to the knuckle. My field servant Nakula came out of my house and asked the reason for my assault to my husband. At this, San Gauntia similarly shouted Dhara Mara. Sukola dealt one lathi blow to the head of Nakula. As a result, he fell down. He lost his sense. Therefore, the story continues. And in cross-examination, she said that the deceased was standing for giving the saga from the Bhagwan.
Single blow, single lathi blow.
Single.
Yes. If this is the nature of evidence, what will be the offense? 304 part 2 goes. That's what he said.
Cannot be. Cannot. First of all, the accused person along with other accused person came with all the preparation and went to the house of Bhagwan. And this Nakula was just a victim of circumstances. Maybe his death was not intended, but they, probably Bhagwan's death was intended. They went there along with armed weapons. They assaulted the Bhagwan. He failed out. Thereafter, Nakula came.
Then you answer that how the homicidal death is caused by which injury. Then the benefit straight away goes to him. If that is the case.
Yeah.
I am trying to modify the nature of offense.
Take one passable so that I can just re-examine the medical officer. Medical officer.
You must do that. You must do that.
Medical.
Otherwise, see, the benefit of doubt straight away goes to him. if that's the case, then he is entitled to acquittal.
I will, give me one.
I was
just the
thinking
medical-
otherwise I'll convert it to 325 or something of that sort.
Both the injuries are possible by one. That will be my endeavor. I'll try to convince you.
Yes. That's the only, and so insofar as appeal number 10 is concerned, 6-month sentence, what is the undergone period?
Lordship was
Almost all of them might have undergone something.
Sankar, Raj and Tarini. They were arrested on 17/5/1994.
Hmm.
They released on 26/1994.
Supolo, 17?
Supala, Sankar, Raj and Tarini.
17?
17/5/1995. 4, sorry.
94.
94.
Bail?
26/1994.
26, 26, 94.
32 days almost.
32 days. 32 days. And after conviction? After conviction, 389 benefit
There
might
was
have,
389
benefit might have been given. And one of them has died. Upendra has died.
Upendra died in the mean. And regarding Upendra and Gautam, they surrendered in court on 12/7/1994 and they released on the same day. So they are not honorable. Gautam.
Huh?
Gautam.
Upendra Gotti. Okay.
Appellant number 3.
Three and 5. Huh?
3. 5 in the meanwhile died.
Yes. Then shall I take it at 2 o'clock?
I think
2 o'clock.
Sir was requesting for Thursday.
Huh?
Sir was requesting for Thursday. Need-
Thursday. Thursday. Now it is confined to this point. Huh?
This point.
I have
Whether
now read it.
Injuries can be possible by one blow or not, and if not,
Yes.
it will be the consequence.
Whether straightaway benefit of doubt will be given to him,
Yes.
or it can be converted to any other
323 or
320, not 325 only, because injuries are serious. 325.
Yes.
325 and sentence will be reduced or something of that sort. Huh? Jyoti, evidence card. Evidence, yes, we'll discuss. Yes. Take the evidence. Huh? Modification allowed कर दीजिए.
Item 4 judgment modification. Item 4.
Item 4 is the modification of judgment dated 11/11/2025.
Item 4.
My lord.
Item 4.
Yes.
Yes. What happened, sir?
This honorable court held that my lord, grant of provision to be accompanied by the pecuniary compensation, pecuniary payment. my lord.
Which part? Let us see the judgment.
Para 13 of the judgment.
Para 13 of judgment.
Modification.
But in the, accordingly, this honorable court directed the appellant
1 minute.
pay rupees 10,000.
1 minute. Para 13. Yes.
In the meantime, my lord, the victim too died since the 2007, my lord. This honorable court directed to payment to the victim 10,000 within 1 month from the date of judgment.
Okay. So victims LR?
LRs, I have not a LRs directed
10,000 rupees.
to the LR.
This is an application for modification for the judgment dated 11/11/2025. Whereby in the this court has directed the appellant to deposit the fine of rupees 10,000 within 1 month to be disbursed to the injured Basant Kumar Shah, that counsel for the petitioner appellant submits, applicant submits that the injured applicant, Basant Kumar Sahu has already expired. Therefore, the fine amount deposited, you have deposited, huh?
No, we
Have
have,
you deposited?
no, we have not yet deposited.
Okay,
It's already
fine
taken
amount to be
direction.
deposited cannot be disbursed to the injured in view of the in view, it cannot be disbursed. It cannot be disbursed in accordance with section 357 CRPC. Hence, he seeks for modification of the judgment regarding head to the submission made by the counsel for the appellant. The paragraph 13 for the judgment is modified to the extent that the amount, the fine amount of 10,000 rupees to be deposited by the appellant shall be disbursed to the LRs of the injured Basant Kumar Sahu. Basant Kumar Sahu in accordance with section 357.
I was saying this case,
One-
but,
1 month's time maybe.
last week, yeah, but it was wished to pass order directing the injured to receive that compensation amount. In that case, I had argued. But
He died.
informant is not there, injured is not there.
Henceforth, what I'll do is injured or LR. In the, that is a better idea. Whenever
1 month's time may be extended,
Ah,
my lord.
and accordingly 1 month time is extended, allowed to the appellant to deposit the whole court. Okay. Yes. Yes.
Item 42 years.
Ah.
Mr. Devashish Panda is a senior advocate is appearing in this case. He is filing.
A small matter, Putao, small matter. Small matter. Yes, Mr. Mishra. Small matter you are talking.
46 got also.
Which one?
46 got also.
You are ready? You are also ready? Which one?
50.
50? Okay. 50, let us put 50. Has the bar passed a resolution for not to work?
No.
Then?
The billings.
Other than from 2 o'clock, everything is closed. Yes.
I am not in any case.
Hmm? You are there, na?
No.
Hey, today you are not there in any case. The small matter is, I told, give it to Mr. Mishra also. Small matter, if you can read. Acha. Yes. Yes, sir.
1 year conviction.
1 year?
Conviction.
325.
My lord.
325, 1 year.
1 year. Fine amount is 5,000. Here is the case, my lord.
Undergone period?
No lordships, my lord. He was appellant, my lord, contesting different village level election. For which, my lord, on merit, your lordship.
Okay. Show me the injured. Who is injured?
PW1.
Show me that. PW1. Okay.
My lord.
You are Sanjay Kumar Pradhan. Yes.
My lord.
Yes.
I know the accused person. I am Tamara by caste, which comes under the SC. The accused is Chassa by caste. The occurrence took place 1/11/2005, which on the day of Deepavali, on that day at about 3:45 AM,
3:45 a.m. While I was present in my shop, bursting crackers on the occasion of Deepavali, the accused came there holding a bamboo lathi and abused me, saying, "Sir, I will kill you." So, saying the accused dealt a lathi blow on my left hand, as a result of which I sustained fracture injury. I was immediately taken to Charmal Hospital. After faster treatment, I went to Charmal PS, where I gave a written report. Exhibit 1 is my report. Exhibit 1 will so and so. Subsequently, the police
Seized my caste certificate on my production. Exhibit 2 is the seizure.
is my signature, where the police
Subsequently, police gave the same in Jimma. Exhibit 3 is Jimanama and so and so and so and so. Okay. Cross examination.
across the accused is an influence Congress
Congress
leader by the time of the occurrence, and he was alive. I am a supporter of the BJP. There is a political rivalry between the BJP and Congress in our locality. My shop is situated near High School Chaka. The shops of Ramesh BC and Ramesh Vishal and Gagan Pradhan and others are situated near my shop. In front of my shop, there is a road leading from the main road to the villages Ubel and Bari Sahi of village Kharsua. It was crowded locality. Nearby shop owners did not come to. About 20 to 25 persons gathered there, but I cannot tell their names. I did not raise any alarm. None came to my rescue. I cannot say the siege of the bamboo lathi, which I was assaulted. I cannot say the color, type of dress the accused was wearing. I went to the hospital with one Ranjan. Before going to the police station, I was given faster treatment in Charmal Hospital. I had informed the doctor regarding the cause of injury. So I went to the hospital after report.
Yes, who is the doctor? Who is doctor?
Dr. PW5.
PW5. Left hand.
16/11/2005, I was working as a medical officer in charge of Charmal CSC. On that day, about 7 a.m. on police requisition, I examined the Khageshwar Behra, so and so. Injuries, bruises of size 3 inch and 2 inch situated horizontally and 2 inch left and lower border of the left patella.
Both injuries are simple injuries.
My lord, simple, and injury number 2 is the grievous.
What is that?
Bruises size of 3.
Injury number 3.
3.
There are 2 injuries only.
2 injuries.
3 कहाँ से आ गए? Injury number 3 is grievous. Just see the only 2 injuries.
2 injuries given. X-ray done.
Just see, there are 2 injuries.
The third on the X-ray done.
X-ray.
That is a fracture of left radius was detected. That has been treated as injury number 3.
And X-ray plate not produced before the trial court.
This is third injury according to you.
1 and 2 external injuries. 3 is the internal injury which was detected on the X-ray.
It is not numbered then.
That is numbered. That is not numbered.
Not numbered, and the X-ray plate not produced before the trial court, and the weapon of offense not produced before the trial court. And you see the time of occurrence, PW1 and 2 is different. The PW1 matter says the occurrence took place matter 3:45 a.m. and the eyewitness matter the PW2 6:30 p.m. And there are, my lord, locality, my lord, some of the informant and the accused, both are, my lord, shop owners.
By injury, see, he says left side hand injured.
Left side hand.
And that is found there by the doctor.
Doctor.
These are
And
major
your
part.
lord,
And
Exhibit number 4 for him.
exhibit?
Number 4.
Page 62 of the PCR, digital print.
Now third injury is there.
And there is a, my lord, huge numbers of, my lord, on the day of Deepavali. Okay, I can two only, my lord, witness, my lord, support coach, okay, corner. All others,
Then
my
who all
lord,
are the eyewitnesses?
PW2.
PW2. He is supported.
Supported, but the, my lord, says, my lord, the occurrence took place 6:30.
Oh, that two things are.
6:30 p.m. And weapon offense, my lord, a bamboo lathi. Lathi has not been seized. And, my lord, the X-ray plate not produced before the trial court.
The PW1 is the injured, huh?
Yes, sir.
Injured.
P1 is the injured. He narrates the incident. He says that I was beaten up by this man. PW2 supports the incident.
Yes, sir.
And that corroborates with doctor's evidence.
No,
What has
doctor
long
says,
minor-
here is the question, my lord, the grievous injury. Your lordship can see the cross-examination of the doctor. All the injuries would be possible by fall. The report was prepared after referring to the injuries mentioned in the OP register and the opinion of the Dr. S.K. Pati, orthopedic specialist. X-ray plate of police produced the X-ray report and the X-ray plate before. Those were taken back by the police after done with. And thereafter, your lordship kindly see the evidence of the, my lord, IO.
PW6.
6. 1/11/2025, I was working as a DSP, Home Guard, Sambalpur. Under the YSA Charmal PS registered the Charmal PS 67 of the Ethic 3 of so-and-so IPC and the so-and-so, your lordship, for 2, my lord. Requisition had been made earlier for examination of the injured, that the requisition and signature on so-and-so during course of investigation. I examined the witness, visited the spots and prepared the spot map by Exhibit 5 and the signature. I seized the caste certificate issued by the Tahsildar.
What do you want to show?
So police your lordship kindly come to the, my lord, cross examination. I have not seized any report of radiologist in the matter.
That's
Doctor Kohile, doctor
He said orthopedic surgeon.
1/11/2000.
X-ray.
Requisition had been made by the Rajat Kaur, the medical. My submission, my lord, X-ray report, X-ray plate not produced before the court, and the weapon offense, my lord, not produced before the court, before the, my lord, during the trial, and my lord, the
That will not wash away the evidence of the injured and eyewitness.
Your lordship, if let it be no grievous injury.
That could have been a more stronger a case
my lord,
for them.
so far as grievous injury, grievous injury is concerned, the doctor says, my lord, the police produced the X-ray plate before
Does the doctor say that after the X-ray,
Police
it
written that.
can be confirmed?
And the police
says the
will-
grievous.
The police says, my lord, no, the doctor.
Once the doctor says grievous, no court can say that no, it is not grievous. It is doctor's opinion. What to do? Maybe it is simple injuries. Once the doctor says, the court has to agree with that. Court are not experts.
And the injury can be possible by a stick, my lord, that has been not produced against the stick.
This is again speculation.
Length. My lord, got
From the evidence, how will you, from the evidence, you have to tell all these things. You can't speculate.
My lord, your lordship kindly see the, my lord, cross-examination of the
It's
doctor.
very, Sometimes it is easy to defend a 302 case, but
My lord.
307, 325 very difficult because injured himself is there and doctor is there. These are the two witnesses.
Yes.
Very difficult to say.
All the injuries would be possible by fall. This report was prepared after referring the injuries mentioned in the OP register and the opinion of the Dr. S.K. Pati, orthopedic, S.K. Pati examine ହେଇନାହାନ୍ତି.
I tell you, examine ହେଇଥିଲେ ଆଉ ଟିକେ strong ବନିଥାନ୍ତା. ତାର ଅର୍ଥ ନାହିଁ ଯେ
Acute ହେଇପାରିବନି. ଯଦି grievous injury, then how could you tell that the simple injuries? Then he admitted that there is simple injury is there and
74 birth means what will be the age?
ନାଇଁ ଏବେ 52 ଭଳିଆ ହବ ବୋଧେ କାରଣ 36 ହେଇଥିଲା 2009 in the year of 2009 his age is 36 now it's 16 years so 36 plus 16 52 years old.
He is a politician contesting election.
ପୁରା acute ତ ଯାହାହେଲେ ବି ଅଛି grievous ଟା 325.
How will you? That's the difficulty. Well, is very difficult.
My lord, if the my lord, it can.
I can
What
give
a
you
stick.
probation.
My
To that extent I can do it. But not
Can it be, my lord, ଗୋଟେ stick ରେ ଯଦି ହାତଟା କ'ଣ ଭାଙ୍ଗିବ ଆଜ୍ଞା? That is the
speculation.
Your lordship,
stick not produced.
And a stick injury 3027 is also upheld many a time.
And my lord, your lordship, kindly see the my lord, the incident took place, my lord, on the occasion of Deepavali.
your lordship,
I know
And
there are
there
many
is
people
no
there.
criminal
Different
intent, no.
witnesses could have been examined. So many things are there. It could be done in a better fashion. But at the same time, whatever they have done, those things cannot be washed away. It could have been done in a better manner. Independent witness could have been there. X-ray could have been exhibited. Everything could have been done. That would have been a better case, full-proof case.
your lordship,
But at the same time, yes.
PW 5 doctors in conference para 3 the injuries might be caused by the lathi and thenga.
I not seen it.
And the lathi not produced before the court.
No, you say that it is not possible, but doctor says it is possible.
No, well, ମାନେ stick ଟା produce ନ କଲେ ତାର length.
How much
କେତେ-
undergone period?
Undergone, your lordship, on the same day he released on bail, your lordship. Surrender on 14/2/2006, bail on 14/2/2006.
No, same day.
Same day.
Same day.
ନହେଲେ ଆଉ ଗୋଟେ ଦିନକୁ ଆସୁ ଦେଖିବେ ଆଉ କୋଉ ବାଟ ଦେଖିବି ଆଉ ମାଲର୍ଡ ଇଟ୍ସ ଏ ମାଲର୍ଡ ଅଲସୋ ଏ ପଲିଟିକାଲ କାରଣ his father is a politician. His father was ମାଲର୍ଡ
You are the Congress leader. You are the
Congress
BJP
leader.
Saman ନିଶ୍ଚୟ ମାତିବ
I don't think there would be any scope
Any
of
other.
any acquittal in this case. If you can get something, if you want, you can adjust.
ଆଉ ଗୋଟେ ଡେଟ୍ରେ ଆସୁ ଟିକେ ଚେଷ୍ଟା କରିବି.
This is not a case for acquittal. PO, I can grant. Not beyond that. Because see, how will you get over the injured witness and doctor's evidence? All these things could have been
No,
done,
no,
that
my
could have been done. So many things could have been done.
See,
They could have tried you for
Some-
307
my
hours.
lord, my lord, eyewitness to the occurrence, my lord, see, the PW2 taken PW1 hospital. My lord, he says, my lord, the occurrence took place 6:45 p.m.
See,
My lord,
while giving a blow, you have said that kill him. That also you have uttered that sentence. They could have tried you for 307, intention to. So 325 they have done it, you should be happy. Find it out. If it can be possible, we'll see. Find it out. Some judgment, something,
my lord,
find out and.
ମୁଁ କହୁଛି ସାର୍ ଆଉ କିଏ ଠିଆ ହେବେ ଇଲେକ୍ସନ ତାକୁ ତା ଭାଇ ଭାଇ ଠିଆ ହବ ତାକୁ ଛାଡ ତା ବାପା ଭାଇ ଭାଇ ଥିବେ ନା.
He's giving some advice, political advice. Parted is which one? We'll do it. You are not interested. No, before lunch, if you want, 12:30, we'll do it. Huh? After lunch, you have some problem. Yes, sir.
Makes your lordship. In this case, the appellant has been convicted under section 354 and 3(1) of the SC Act for a period of 6 months. In this case, I don't know what happened.
354 and
3 SC Act.
Okay.
So far, 354 is concerned, no evidence is as against the present appellant. And so far, 3 SC Act is concerned, the prosecutor, the victim girl, only she has stated in her examination that
HEC.
just I'm placing the evidence of
Yes. Let us see the prosecutrix.
prosecutors.
Item
Without seven,
sir. Item is Sarat Parik. Number is where?
Before the court, I'm placing her.
Okay.
I know the accused. I belong to Dhubabai caste. As such a member.
1 minute, 1 minute. I'll let you. Parted, it was parted, huh?
Parted.
A PW?
7. Supola
7, huh?
7.
PW 7, the victim. Yes, victim. What does he say? Let us see.
Initially, actually, affair was lost. And subsequently, compromise was filed. But in the court, she has stated that I have not signed any compromise. She has signed. And this cross-examination, she has stated that I have not signed in the compromise.
Compromise. Oh, let us see.
In this case, what happened? I know I belong to Dhubabai caste. As such, a member of scheduled caste category. The accused is Chasabai caste. He is not a member of scheduled caste, of scheduled tribe. When I lodged the affair, I had not married Exit 4. Is the Exit 4 is the affair lodged by me, and Exit 4 by 1 is my signature. Police seized Doctor Exit 2 by 2 is my signature on the injury report.
About 3 years back, 4.
Sir,
About
about 3 years back, the entire episode has stated. About 3 years back, on a day at about 10 a.m., I had been to wash cloth. At that time, I broke a branch of mango tree from mango grove. At that time, the accused came and pulled my blood.
Huh?
When conviction is under section 354(1) and 440.
2 months.
You see, if I register
Undergone period? How much you have undergone?
no, custodial. He is also now taking advocate.
1 year for 354. 1 year for 354.
1 on the 354 and the 4.
448. 2 months. Yes.
458, 354, 294, of IPC related section 3(1) XI of the ACR.
Yes.
While acting all the offenses, consisted the for the offense, 1 year plus 354.
Yes.
Here there are
Who is the victim, girl?
victim
PW?
One.
PW.
PW1.
Yes. See, let us see.
Your Lordship,
See her deposition.
I am reading out the cross examination.
What are the allegations? What are the allegations? 5 years back, in the evening, while I was cooking food, the accused entered into the house, got hold of me and from the bedside, and 9.
39.
Huh?
PO guest.
Okay. Get a report. Get a report. Huh? Get a report. Oh, 39 report. Huh? Right.
Item 52, my lord. Your lordship appointed a honorable skill.
Item?
Item 52. But the matter was, of ours, Chambers matter.
Nero Bhuya.
Yes, my lord.
Yes, madam.
2 months of confusion. 2 months of confusion.
So MA Query is appointed. Why you are not there? See, this is very embarrassing, you know. Nobody comes and we appoint MA Query and the MA Query. But you will also have to do something. Do one thing. In the item 46, I am appointing you as an MA Query. Okay. And Tuesday,
46.
which matter?
46
Choto matter.
48, 2.5 years.
How many years standing you have? How many years standing you have in the bar? Huh? 13. Then you can do bigger matters also.
Except name of NC-pati reflect any matter. Kindly, my name should be reflected Vishwalpa.
NC-pati
Yes.
record how matter siko.
She is daughter of Kansi.
Okay. Adi hochi ko matter NC-pati.
That was item 52.
52 is one.
Yes.
She will also do. You also be there. I am giving you one more 2 matters. So you prepare and.
NC-pati to activate. See me right.
What's it? मन रखते जुटे NC-pati का नाम जो appoint है ऐसे में किसको. Apart from that, आज एक छोटा मेटर we find out, it give the brief.
2 months.
So get ready Tuesday and come in that matter also. You assist both the matter. You assist.
36
Huh?
36 would achieve 77 days.
30?
36 item.
Yes.
These are not 6 months, 6 months, and 505 months.
36.
36 months. Please,
36, huh?
77.
354 and 3 SCST actions there.
56 years.
इक्के धड़ो. As the whole difficulty is, if somebody is not appearing, why are you writing the name? उतार के copy paste कर order निकाल दो. If nobody is appearing, you say none appears. Tomorrow he'll say that I have been appearing. He might not appear. On the request of the legal counsel for the appellant, there is a request. Sorry. Take your mobile number. Give your mobile number. I'll appoint you in a couple of matters. Get ready and the registry will call you. Registry will call. In all other matters, see what I'll do is in all the matters, in small matters, today I am making a proceeding that none appears on call. And on the next date of hearing, MA Query will be appointed. And on Tuesday, en masse I'll appoint MA Query. Otherwise, you can't keep on waiting for them. In all the matters, I'll appoint MA Query from the panel, and these people are there. At least they can prepare and argue. Poco matter, small matter, all these matters.
6 months.
When the matter was
6 months.
none appeared.
6 months.
And even earlier also none appeared. In the interest of justice matters, these matters are has been listed in the weekly. Despite that, none appeared. Hence, in the interest of justice, matter is adjourned to Tuesday, next Tuesday. And if none appears on that, amicus curiae will be appointed. So very short matter for you. You take the name and give 2 matters to her. It's okay. Huh? All these matters, I am passing a common order. In every matter, I'll say that since nobody is appearing, I'm giving a last opportunity, and Tuesday amicus curiae will be appointed. Tuesday I'll appoint amicus curiae. Wednesday these people will do it. Okay, Thursday.
Yes,
Thursday. Please be there on Tuesday. Yes. Which item? 52. 52, the one. It is urgent to Tuesday. No? Tuesday. Both of them will do it. Both of them. Yes. Yes. Give the number to her so that they will contact and discuss themselves. Okay? Yes. Next. Anyone is there? So the oldest matter pick up. The oldest matter. अभी तो order कर दिल ना मैं किसी
16 या जाते हैं 17
छोटो मिट्टी सब छोटो मिट्टी देखो ना किसी तो करी भाई
25 और 26 टा नेक्स्ट वीक है जो फर्स्ट वीक
41 सरला 41
no 40 41 and 41 सरला 40 43 मेंशन करते हैं आगे में आता है अभी फर्स्ट केस
46
46 ना
हैं
ना
नहीं
46
46
46 से कॉल की गलत है
6 month 3
auditor has to in he is in another court, so he will come at
46.
2:30, yeah.
What about 7 years 40
मेंशन करते हैं फर्स्ट आइटम में आता है ऐसा लास्ट टाइम मेंशन करते हैं कि ये 40 और 43
What about 36
36 return इसके जरूरत है इसमें दाखिल
26
SC
36 because 6 में
14 नहीं है 14
ऑर्डर पास कर दे अप टू 16 ना 15 ऑर्डर करते हम इसको पे लेकिन नेक्स्ट प्लेट में आते हैं हां
But item number 21 yellow seal, 325 34 2 years conviction. जो थे कि 219 से already अच्छी on period order का custody certificate भी दिया है.
Code है item
21 item 20 years. What is the item? 21 238 of 1999 21 Nakura.
21 huh?
Yes sir. These also 290.
Already undergone how much?
219 days.
7 months.
It is 7 months, 7 8 days. 21. 46, sir. 46, sir.
Leslie, how is it 46 up? So निकाल 46.
46.
May I, Your Lordship? I am appearing on behalf of Mr. Dhananjay Munda. May I submit? Your Lordship, the appellant has been charged with a misdemeanor under section 323 and 506 of IPC. And the prosecution case in short is that about the informant while returning with a constable after investigation of a case from a different village. He got a reliable information that the accused were planning to dispose the foreign liquor. Based on that, he tried to intercept them on their way. And the accused then allegedly involved in a hustle with them. This is the case, Your Lordship. In order
Conviction under which offense?
323 and
323.
My lords.
Only 323.
And 506.
506.
Both are for 6-month consent.
6 months sentence.
6 months,
Higher,
3 months.
higher is 6 months. 506, 6 months. 323, 3 months.
3 months.
6 month total
6
substantive.
months.
My lords.
Yes.
So the learned trial court has erroneously passed a judgment without following the principle of beyond reasonable doubt. No, the case has not been established beyond reasonable doubt. Still, the conviction has been made, basing upon the only deposition made by the police constable who is
Injured either. PW5.
only the injured eyewitness. Does it hold a probative value that even after non-corroboration with the medical reports that has been presented before the
Let us see who is injured. Injured.
PW5.
PW5, Your Lordship.
Okay. Let us read it.
There are other eyewitnesses to the occurrence.
And every eyewitness has turned hostile.
Lakshapati Kumar, huh? Lakshapati Kumar. Yes, read it.
Lordship.
Read it. PW5.
PW5, my name is I know all the accused persons standing in the dock. I am the informant of this case. On 28/12/2007, I was working as an ASI of police attached to Borda outpost under Keonga PS. On that day at 2:40 p.m., on getting reliable information regarding transportation of illegal foreign liquor by the accused person, I reached at so-and-so Chowk and found the accused person, namely Lakshapati Kumar, Jani and Juad, coming out of hotel situated at Chowk. Out of them, the accused Lakshapati Kumar abused me in obscene word like that and threatened me with life, and then he pressed my neck. At the time, accused Hari reached at the spot, abused me and threatened to assault. The other two accused person, namely Jani and Juad, also abused me and threatened me to assault. Accused Lakshapati Kumar snatched away my shoulder badge from my shirt uniform. Police constable number so-and-so, name so-and-so, has accompanied me from the outpost to the spot. Lichu Maji, Abhi Chinda, and some other person have witnessed the incident and they intervened and rescued me. The prominent eyewitness that has been mentioned, Your Lordship, and everyone turned hostile. Then, after the incident, I went back to the outpost and then went to Kegaon police station and lodged a written report to the OIC Kegaon PS. This is the said FIR marked as Exhibit 1 and so is my signature. I was sent to Chaparia hospital for my medical examination. This is my signature and on cross-examination, my lordship, he had admitted that no substantial material to corroborate his claims has been recovered. For example,
let us complete reading this.
Lordship. May I read the cross-examination, Lordship?
Yes, read it.
The subshell Chowk is at a distance of 6 kilometers from Borda outpost. The Keongaon police station is at a distance of about 20 kilometers from Borda outpost. After the incident, I went to Keongaon PS and reached at about 8 p.m. at Keongaon. It is a fact that I have entered the fact regarding my departure from Borda outpost to Keongaon PS to lodge an FIR in the station diary entry. I cannot say if the said station diary entry has been seized by the OIC Keogaon PS or not. I cannot say the exact time where I left my Boda outpost.
Who is doctor? Doctor.
Doctor is PW7, Your Lordship.
For the injury.
Who is the medical? Right.
Mhm. May I read, Your Lordship?
Yes.
On 28/12/2007, I was working as on police requisition. I examined Chandra Singh Dansena, the then ASI of Police Boda, son of that, and found 4 numbers of abrasion, that is scratch mark of size 1.5 cm into 0.5 cm, located at the right side of the neck. Injury is simple in nature and might have been caused by firm and sharp edge object like nails. The injury was fresh and caused within 6 hours of my examination. I prepared my report on the form supplied by the police. This is my report, Exhibit 2 by 3.
Yes.
And upon cross-examination, it is stated that the injury is not fatal and it would not cause the death of a person in ordinary course of nature. The injuries are also possible by self-inflicted. And another opinion, it is a fact that if a person standing on the front press the neck of other person by his right hand, his imprint will be fixed on left side of the victim of the neck. It is a fact that I had prepared my own report on 31/12/2007, and I prepared my report going through the OPD ticket prepared on 18/12 as 28/12/2007. It is a fact that the OPD ticket is not available in records as it has not been seized by the and it is not a fact that I have not examined Chandra Charan Dansena on 28/12/2007 and did not find any injury on this person, and I have prepared my report.
Yes.
So Your Lordship, there are 2 essential doubts that arise before convicting a person from beyond reasonable doubt. First, Your Lordship, is that no material has been collected or seized to ascertain that does the informant went to that place through official capacity, or his total story that he has made that he has confronted by the accused has not been substantiated by any witness. The witness himself claimed that they helped him get out from the clutches of the accused. They did not corroborate. The medical report say it is a self-inflicting injury. There is a presumption, clear presumption made by the medical officer about the position of the nail mark that is present in the neck of the accused. So these all creates a substantial amount of doubt, Your Lordship. And without answering that doubt, the learned court had directly plunged into conviction. So, Your Lordship, I submit.
The victim says that you throttle him.
Your Lordship.
And the doctor finds that there is a mark in the neck. How will you get over that? 323.
Exactly. The question has been answered in
and
her
all
submission also.
attending circumstances are also staring on the face of it.
Your Lordship, only relying upon the informant doesn't hold that probative value without corroboration with other.
Corroboration is PW7.
PW1 is an interested party, and Your Lordship, and he has explicitly not mentioned about what deposition the informant has made. That why they went, where all these things were missing, and creating a probable doubt about the existence of
If any case you pick up, You want to create doubt, you can create doubt. But how will you get over these witnesses? PW 1 and 2. 2 is the injured state, very specific allegation against you, saying that you have pressed his neck. And the doctor says that he found a mark on the neck.
Can I demonstrate, Lordship? Can I demonstrate one thing?
Huh.
If I am pressing someone's neck from the right, which he has deposited himself that he pressed
Where
his neck
PW2 has said that right side neck or left side neck, whatever. These are little small aberrations in the evidences. That those things are immaterial.
May I have a moment to confirm
Yes.
with the deposition of the
Hmm.
victim?
Victim is PW3, na?
Five.
3, eh?
Five.
5, yes.
Point number 4 of cross-examination, that is cross-examination by defense.
See, Chief, it says that threaten me with life and then he pressed my neck. As you say, right neck, left neck, and all these things. The cross-examination is neither here nor there. There is a mark in left side or a mark in right side. How does it make a difference? You press the neck, that's all. And there is a mark in the neck.
The doctor has opined that it may be a self-inflicted injury. It can be. No.
He will press his own neck.
Might be, because your lordship see the deposition of the medical officer. She clearly state that if a person, she made a presumption out of all the experience she had in all these years. She had given a statement that if a person standing in front of me and holding my neck, all the finger imprints will be at the left side. And this is a fact, your lordship, that is important to question your lordship's answer to question. That may not be negated, your lordship. That is a fact that being a police officer, he might, with due respect, he might prepare his own case just to falsely implicate the petitioner by using his official power and also writing skills.
Independent witnesses were become hostile. 2 to 4. 2 to 4 were the independent witnesses. PW1 is a official duty. Was along with the official duty, along with the PW7 is a input. 2 are the independent witnesses and local agents. They turned hostile.
1, 2, and 5. Yes, sorry. 1, 5, and 7. That's right. So therefore, the important witnesses are 1, 5, and 7.
6 is the ID.
6 is
6 for the conviction.
But the doctor says that there are many injuries.
There are 4 injuries.
4 injuries.
4 nails there. Obviously, 4 fingers, then how that can...
Huh?
Yes, yes, already on. If you were
I'll give you, huh?
Lordship?
I'll give provision of offenders. Benefit. Okay. Did you follow what I'm going to do?
No, I am appearing first time in this. Okay.
In fact, if somebody is convicted, either he has to be sent to the jail, sentence is 6 months.
Lordship.
During the trial and appeal of whatever, he has already undergone 19 days. 20 days he has already undergone. If I will dismiss this petition, then he has to serve out another 4 months. 4 months and 10 days, whatever. Instead of sending him to jail, I will treat him as a probation of offenders, and I will say that you file a bail bond, you don't go to jail. You will not go to the jail, but your conviction is happened. You have any problem?
I have not got instruction regarding to this.
Eh?
Just one moment, if your lordship may.
comments about conciliation or something.
That's 32 years.
Okay, lordship, as your lordship, please.
No. You tell me if you are aiming at an acquittal, then we have to further. But it's not a case of acquittal. Doesn't look like. Yes. Who is your senior?
I'm on behalf of Mr. Dhananjay Mund.
Dhananjay?
Mund.
Oh, and ask him outside and come tell me.
Just a moment, Lord.
Telephone and say that PO, Probation of Offenders Act, the court is interested to give. Just ask him whether he's working, I don't know. Ask Mr. Munda and tell. "19 days undergone."
He got arrested on 30/12/2007. He attended bail on 14/1/2008.
Let's see, these witnesses are there. Injured witness is there. Doctor says, what will you do? How can...
Injured is a police officer. Otherwise,
injured is a police officer.
you are discharging his duty. PO undergone bail.
Doctor is very specific. Cross-examination is further clarified. Doctor says.
They made it.
That's the problem.
Pardon for the interruption, Your Lordship. Yeah, Lordship, yes. Yeah.
No problem?
No problem, Your Lordship.
Okay, you go. Okay. Yes. Any matter?
Obliged, Lordship.
I don't think anybody is there. Any matter? Nobody is interested. You have persuaded, it seems, to come. No, he has been since 12 o'clock. He has said no. He might have persuaded people not to come.
He is having personal.
So successfully you have done.
Pass. I'm not pass.